Lester. We are here today for a final pretrial conference in this case ahead of a trial scheduled for June 20th and 21st. We are proceeding today partially in person and partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure filling in for Prosecutor of Record Isaac Sneed.
Samaris Hennigan on behalf of Donald Lester.
All right, and Mr. Lester, I believe, is in the jail Zoom 2 device. Mr. Lester, are you there?
Yeah, I'm here.
All right, so I don't know what's going on with the camera. We can't see you. It looks to be shooting at the scene. Almost. I'm saying that we can't see you, Mr. Lester. So, Ms. Hennigan, where do we stand? Are we ready to proceed to trial on June 20th?
Thank you, Your Honor. I met with my client yesterday and did make the final offer to him with regard to plea agreements. My client has declined to accept the plea that was offered by prosecution. I also was informed by my client that he has filed a few motions. I guess you would say pro se. I have not seen those motions myself, but he says he mailed them to the court. He does have many objections to the proceedings. That being said, the next step that would be appropriate with regard to our legal procedures would be to go forward with trial. I am prepared to do that, though I do believe that my client will object to that, Your Honor. So I do want to make sure that I represent his wishes as well, while I still inform the court of whether or not I'm ready to proceed. So I will be ready to proceed for trial next week. That being said, my client does not want to go to trial as he feels that
Right here, Lester's attorney tells the court her client refused the prosecution's plea deal. Classic sovereign move, turning down a lifeline, because accepting it would recognize jurisdiction. Legally, that's nonsense. But here's the irony. By showing up, by speaking, by even objecting, Lester already acknowledges the court's authority. His lawyer knows it, she's doing her best to protect his rights while still honoring his wishes. This is where legal ethics and human stubbornness collide. Would you defend someone who refuses to believe the system even exists?
For appellate purposes for him, that he was upset that I agreed to a trial schedule at a past hearing, and I did try to explain to him that that's just a procedure, that the court is on time frames according to statute, and that at some point we do have to set a trial schedule, even though it was my intent to continue to try to negotiate this case for him along the way.
All right, to the extent that there's any objection based on court's jurisdiction,
I can't hear you. Can you speak up, please?
To the extent that there's any objection to proceeding to trial based on the court's jurisdiction, I would deny that, as the court does have jurisdiction over this case. It is a felony case involving an alleged felony which is alleged to have occurred within Lenawee County, state of Michigan. This is the circuit court for the Lenawee County, state of Michigan, and therefore jurisdiction is appropriate. Ms. McClure, is there anything we need to address from the people's side?
The people have not received any motions that have been referenced, but as far as I know, we are prepared to proceed to trial next week as well.
Right.
All right, so do we have proposed jury instructions and voir dire questions yet?
The judge calmly asserts the obvious. The Michigan Circuit Court does have jurisdiction. This isn't debatable. It's like arguing gravity doesn't apply because you never signed a contract with it. The prosecutor stays professional, noting she's received no valid motions from Lester Translation. His legal paperwork likely landed in a shred pile. This moment shows judicial patience at its best. Remember, judges can't just roll their eyes, even when they want to. They have to build a clear record, brick by brick, so the appeals court later sees every procedural box checked.
We do not, I know I spoke with Mr. Sneed yesterday, but I'm certain that we can agree upon those within the next day or so.
I see some in our file, so maybe he's drafted them and just not.
Yes, he was working on them.
Okay, so I'll need those by the end of the week so that we have an adequate amount of time to get prepared
Right.
for trial.
I would also like to intervene here real quick, but that being said, I sent over there. So there should be somewhere in y'all file that y'all should have it.
Now, Lester claims he hasn't talked to his attorney for months, that his warrant is unsigned, that his due process is violated. We've officially entered the sovereign script. These arguments pop up in fringe forums where legal terms are copy-pasted without context. Unsigned warrant sounds shocking until you learn digital signatures and clerk stamps are valid under Michigan law. This rant isn't strategy, it's self-sabotage. You can almost feel the defense attorney's frustration. She's prepared for trial, but her client's stuck fighting imaginary dragon.
Your Honor, I did.
And personal. And like I said, I haven't talked to this woman since March. She told me that I was going to be released out for bond, and I haven't heard anything from her since then. I wrote her a letter. The first time I seen this woman in about 2 or 3 months, his first time was yesterday. And she doesn't represent the said name anyway. I've talked to her about that situation too. Somebody's not being truthful here. And I've been sitting here almost 10 months without a bond or even so much as calling my witnesses. She's never asked me anything. So my due process is being violated. Also, I'm sitting in here on an unsigned warrant. Unsigned. A probable cause warrant. They're trying to make it look like they arrested me for those charges, and it's not what it was for. That's not what it was for. I was arrested for driving on a suspended license from back in 2016. That case got dismissed.
Your Honor, I did inform him
He's not
yesterday.
addressing none of those issues, Your Honor. Period.
Mr. Lester, I need you to stop interrupting people, okay?
Here, the judge delivers a mini law lecture worthy of a first-year class. Subject matter jurisdiction, personal jurisdiction, and the lawful arrest element. Every word is deliberate. For viewers, this is gold, because it shows why courts don't just argue philosophy. They argue facts. The judge even explains how habitual offender enhancements work, clarifying that they only matter after conviction. Lester, of course, sees this as proof of conspiracy. But in truth, it's transparency, open law, explained in real time. This is what sovereigns miss. The court isn't hiding authority, it's defining it.
What is it that you wanted to say?
I did inform him yesterday that the charges he was facing could, that it's up to 14 years because there's consecutive sentencing available on those charges. He has a felony that is up to 10 years and then 2 R&Os which can be sentenced consecutively if that were requested and or if the court were to do it. And I informed him of that at the time that I was telling him about notice, and he asked me about that yesterday, and I reiterated again yesterday that that is not why. That was not why he's facing that amount of time. It was simply me telling him worst case scenario in this matter.
All right, so to the extent that personal jurisdiction issue has been raised in addition to subject matter jurisdiction, and again deny any request on those bases because the court again has personal jurisdiction over Mr. Lester, who is a human being located in Lenawee County, Michigan, and alleged to have commit a felony crime in Lenawee County, Michigan.
How did I commit a violent crime?
With respect to the argument that Mr. Lester made regarding the right to resist an unlawful arrest, that's why the court is having a trial. One of the elements that the prosecutor needs to prove in a resisting and obstructing case is that the officers were on duty, acting lawfully, and made a lawful arrest that Mr. Lester resisted. So that's the purpose of the trial. With respect to
Lester keeps interrupting, and the judge finally hits mute. That's not censorship, it's courtroom management. Every judge must maintain an orderly record, and constant talking over others can literally invalidate transcripts. Yet Lester's interruptions also serve a purpose for the audience. They show what defiance looks like when it meets structure. His insistence on making a record ironically prevents one from being made. The tension's palpable. You can almost hear the sigh behind the gavel. If you were the judge, how long would your patience last?
Issue about expunged convictions We're not even to that point yet. The habitual offender issue comes into play only after a conviction has entered, and then the court has to determine whether the convictions listed in the habitual offender notice in fact happen and can appropriately be used under the statute for the sentencing enhancements that have been notified in the information. And so,
Okay. So
this
whenever you get done, I'd like to address issue 2, please.
all right, I'm going to mute Mr. Lester because I can't have people talking over me while I'm trying to create a record. We're willing to plead guilty to possession of methamphetamine in a park. That's a 2-year maximum possible penalty, but the prosecution has also agreed to credit for time served or fines and costs.
And here's the tragic twist. The prosecution offers Lester a plea that could get him released immediately on time served and a personal recognizance bond. Any rational defendant would leap at that deal, but Lester rejects it because, in his mind, accepting would mean submitting to a system he doesn't believe in. It's a perfect storm of pride and paranoia. His attorney tries, yet again, to help him see reason, but he's locked in a psychological prison even tighter than the one he's sitting in. Sometimes the biggest bars are the ones we build ourselves.
And a personal recognizance bond release until the date of the sentencing. Is that all accurate, Ms. McClure?
What is that? That
Yes.
is crazy.
Yes,
All
that's
right.
accurate, Your Honor.
And Mr. Lester is not interested in agreeing to that plea. Is that correct?
It's my understanding, but it seems that he would like to say something about it, Your Honor, so I prefer that he answer that question himself.
Yeah, I would like to say something because of the fact that you keep trying to let me out on a PR bond and you want me to come back to court for sentencing, but you won't let me out to try to get my witnesses and gather the evidence that I need to be able to present it at trial. I haven't even went over this one. I haven't even went over any kind of defense with this woman. I am being prosecuted and persecuted by her and a prosecutor. And it's obvious. It's very obvious. It stands out. I haven't talked to this lady. I don't know nothing about that. I told her what it was then. And
Mr. Lester,
you keep trying to cut me off.
well, that's because you won't let me create the record and do my job. So I'm
trying to do my job. You're not the one sitting in jail, sir.
Your Honor, will you
All right,
please
so
mute my client? I don't want him to.
Record should reflect that. The record should reflect that Mr. Lester had. I'm sorry. So, Mr. Lester, the question I'm asking and that I need an answer to is you've heard the offer that I've indicated the prosecution has made to you to resolve the case. Do you or do you not want to?
No, I'm not, because they had no business arresting me, Your Honor. And I wasn't bothering anybody.
A simple no is fine. That's all I needed. All I needed was.
So where does this leave us? The judge confirmed jurisdiction, the trial date stands, and Lester, still clinging to sovereignty myths, marches toward another likely conviction. His refusal of a favorable plea shows how ideology can override self-interest, turning legal misunderstandings into years behind bars. This case is a masterclass in courtroom composure and the limits of judicial patience. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Justice may be blind, but it definitely sees through excuses.